If you've been arrested for drunk driving, the first call you need to make is to attorney Ted Morgan. You can't afford to go it alone. You need to know your rights. You need someone with the experience to put your DUI behind you. 7 days a week, 24 hours a day. Call 706-317-5733. Ask for Ted.
Call Ted Morgan Law when you need a lifeline.
Hello and welcome back to DUI Law, Real Talk with Ted Morgan. Ted is a seasoned trial attorney who has spent the last 30 years defending drivers in DUI and criminal cases in Georgia. I'm Lisa Mosbey, and in today's episode, we're talking about what actually happens at your first DUI court date in Georgia and how to prepare for it. Ted, welcome. Thank you so much for joining me again today.
Thank you, Liz. It's great to be back again.
You know, when someone is heading into their first DUI court date in Georgia, what is that appearance typically called, and what is the purpose of it? What's going to happen at that first appearance?
Sure. So most courts, that's going to be referred to as your arraignment in Georgia. Some call it your first appearance. And it differs from court to court sometimes because certain counties in Georgia, they have large populations. They have a state court that handles your misdemeanors. It's literally called the state court of whatever county. Other counties, they don't have a state court. Then you're usually going to a probate court. And so what is your first appearance? They may just call it that. But typically what that should be is what we call arraignment, where you're literally informed of the charges against you, which may sound kind of redundant and obvious, but it is a constitutional right under U.S. and Georgia Constitution that the state inform you of your charges. And part of that is the state drafts in state court, they're going to draft an accusation, the prosecutors that literally accuse you of everything they want to accuse you of. And it may or may not be exactly what you got a citation for. It may be DUI plus something else that wasn't charged, or they may drop one. But that's what the first appearance is all about. And I think some people think that the first appearance is their first and last opportunity to, quote, get a deal or cop a plea and get a great deal. It absolutely is not. And I tell my clients, we're not trying to rush in and get a plea at an arraignment or first appearance for a lot of reasons. And usually it's because we don't have a lot of information at that point.
And two things here. Is your attorney usually with you during the arraignment? And what is the sequence of events when someone walks into the courtroom for the first court date?
Yeah, and a little bit of that's going to depend on the court, because if some of them are busy, I know where I am, some of the state courts, on your first appearance, you may just check in with a front desk and they say, okay, you're here, you showed up. And unless you want to walk in and end your case right now and enter a plea, then you can plead not guilty and we give you a new date to come back for the next stage. But you certainly can go to that without an attorney, but you might save yourself a lot of time and money by not going by yourself, going ahead and getting an attorney, because sometimes you can absolutely waive the process, but you can't do both. You can't not show up and not hire anybody. Then you'll get a failure to appear and a bench warrant for your arrest, which won't end well. That just complicates things where it shouldn't have been. So you can go by yourself. If you do, you plead not guilty and you walk out and find an attorney as soon as you can.
And do you always plead not guilty?
Well, I've been doing this for over 30 years, and I don't recall ever taking anyone in on a first appearance and pleading guilty. And Lisa, the reason is primarily your client gives you what they recall, what they know. But that is only one side of the story. And even though we may not agree with what the other side of the story is, which is whatever the arresting officer puts in a arrest report, we don't even know what that is. And so if there is a problem with the arrest, for instance, generally your client's not going to know that. That's the lawyer's job to figure out. And most of the time we figure that out from what's in the officer's report, and then looking at the arrest video, maybe. Sometimes we get a hint of it from our client, but you can't get to the end of that conclusion. Can't get to the end of that without seeing it all. So generally, no, I don't walk them in and plead them guilty first opportunity. That's, to my opinion, not doing a very good job for your client.
Sure. And I don't think people realize that if you've never been in that position, you don't know what to expect and what to move forward, how you'd move forward during that arraignment. So after the arraignment, how does the case typically move forward immediately after that first appearance?
So you're going to get another court date, whether you have a lawyer or not at that stage of your first appearance. You're going to get another court date. Most of the time, in your larger courts, like state courts and the larger counties, that's going to be either a status conference or maybe even a pretrial conference, depending on how the court moves their docket. In other courts, some of the probate courts, your first appearance, they'll read you a bunch of rights. And if you have an attorney, a lot of times there we, for various reasons, one being, hey, we don't have what the state is supposed to disclose to us at this stage. And so the judge naturally sets it off to some other date that might be firm to do a pretrial conference, for instance, or it might be just another check-in date. And that's, not necessarily the same path that it's going to go if you don't have an attorney. I think some folks who are unrepresented, their case progresses quicker and more decisively because you just don't understand what your options are.
And Ted, what decisions and discussions are happening at this stage in the case?
Well, we're looking at the evidence and we're talking to the prosecutor about the case. Sometimes you have a chance for an early resolution just because maybe the prosecutor sees what you see and there's not too much disagreement on what happened or what didn't happen. But, at the pretrial conference stage anyway, you're getting hopefully closer to finding out if you can reach an agreement, a negotiated plea to the case, which doesn't necessarily mean a DUI, just some agreement of a process, of a way to solve the riddle. Okay. But if you can't reach to that stage, sometimes it's a waiting game. It's a who blinks first. It's a little more strategy and a little more work to figure out if this is a case you got to go to trial.
Yeah, there's a lot of moving parts involved, and you really do need a maestro, if you will. It's like a band, and you're getting that music to play. How does preparation, like how does someone show up and present themselves, come into play during that first court date or any court date? Does it matter?
Oh, it definitely does. And I'm not at liberty to disclose all my trade secrets, but we take a lot of time and a lot of effort when we know that we are going to court and your client's going to sit there for a hearing or, heaven forbid, a trial, if that's where we end up. Then we have, I think, a pretty extensive preparation for our clients where we send them some things to read, to think about, and then we take some time to just sit down and talk about everything because sometimes your client's never going to take the stand. But if it's a bench trial or a jury trial, there's still eyes on you, and you've got to make sure that certain things don't happen, certain mistakes that people just don't know are mistakes in a courtroom. So there's some preparation there.
Where do people get confused? I'm going to push on this one a little bit. I want some answers. I want a little more detail here. Where do people tend to get confused? What mistakes do they make during that first court date?
I think one is just confused maybe about whether they should testify, whether they should open their mouth and say something, even if the judge asks something. Some judges just do that knowing that the attorney is really going to answer. I think, too, is making that decision of, hey, these are the issues in the case. These are the factual issues that you need to deal with if you want this story to be told. So are you up to it? Can you do it? And of course, we're also trying to help our client by sizing them up. Do we think they can do it and do it effectively? If they can't, how can we help them get there? Because testifying in court is not something that comes naturally, I don't think, to any of us, and particularly when it's your rear end on the line, you tend to be a little nervous, and you tend to also think that you know what you need to say, and that sometimes clients do. Most of the time, they do not. And so we try to help them through, hey, this is the stuff that's really meaningful and relevant. Don't waste a lot of time talking about this other stuff that's not. And yeah, sometimes there's stuff that for a lot of reasons we don't want to talk about anyway, and we have to pull that out of them so we can make sure they don't ever say it again. That kind of stuff.
How does having legal representation at that stage start to affect what happens next in the case?
Well, I think with the experienced DUI attorney, what you bring in is testing the will of the prosecutor. How bad do they want to get what they want? What are they willing to do? They may say they're willing to go to trial, but in the end, they've got hundreds of cases, and maybe they've got one they'd rather spend that time on than your client's case. So hopefully what we bring is just the expertise, know the law, know how we can use it in our favor, and know when it's not in our favor, know when there's things in the case that, hey, this is going to hurt you more than you're realizing, more than you're giving it credit, and trying to help them make an informed decision on the right facts and the right law versus what they maybe came in with some impression, their buddy got off because of X, Y, and Z, and that's going to get me off my case. That's rarely, if ever, applicable, and all these cases are different in one way or another. So you're bringing them into an informed decision to do what's best and or give them at least an option, right? We can go this direction or we can go the other, and so they know the real risk of each. And then the client decides, or they say, you tell me what to do. And of course we will.
Would you go through a bit of a timeline for us, for somebody who might have been arrested for a DUI or have somebody in their family that this has happened to? Take us through a timeline. The first initial appearance in court is an arraignment. What happens after that? How long do these things take? How long can you go from start to finish with a DUI?
Lisa, a lot of that depends on the court, because there are some courts that move their dockets quickly and some that do not. And again, back to the small county, big county, some of the smaller courts, their dockets aren't that large, so they get to you quicker. But, I tell folks, look, this thing can be over in as little as 3 or 4 months if you really want to push it. If you don't, then it can be 6 to 9 months and longer in some busy courts. If we get to a point where we can't reach an agreement and you're not willing to enter a negotiated plea, then the only thing else to do is to try the case. So you're on a trial docket. Well, if there's 20 cases ahead of you, and how often does the court have trial? How many of those really go to trial? You have no idea how long you could be sitting out there waiting on your turn. You're just in a queue. So it's heavily impacted by the court you're in and how big a caseload they have. How often do they have court, which can be a function of budgets and everything else. But if we know what court we're in, I can give you a pretty fair timeline on that. But generally, yeah, you're going to have your first appearances. You're going to be entitled to have a pretrial conference. You may be entitled to have some motions and hearings on evidence and legal issues before there's ever a trial in the case. And that can further complicate the timeline, because when is the court available to hear those motions and give you your hearings? That can push stuff back. So that's why it's hard to just give a a definite, hey, all DUI cases are over in 3 months or 6 months. You can't say that.
A DUI case is over as soon as you stop drinking and driving, right? We don't have to face that. We don't run into those problems. When you said 3 months, you said in as little as 3 months, and I'm thinking that is not a short time frame. In as little as 3 months, so this is a long, drawn out process. Let's wrap this
Indeed.
all up for folks. What advice would you give people who are listening to this today?
Well, mine is considered self-serving by some, but we wouldn't be here if we didn't add value and help folks. And we really try to do that. We try to take a customized approach at some point on every case. So find yourself a good, experienced DUI lawyer, and let them work for you, because you're bound to make mistakes and errors without an attorney. Whereas with a good one, what I tell folks is I don't guarantee a result, but I do guarantee I can get you the best result that anybody can get you in my area. And there's a difference there. And one of the things that I see that just pains me is when someone walks in and this is number 2. And I say, what happened on number 1? And they tell you, and did you have an attorney? No, I didn't think it was worth it. And sometimes that's just the worst news in the world, because when you're on other than number 1, the penalties, the price, everything goes up. The licensing, suspensions, everything goes through the roof. And sometimes that's where we find ourselves, is that we're at number 2 or number 3, and they didn't have an attorney on the prior. And not saying we would always get them out of whatever happened, but certainly would have been better. That's just the basics of any area of criminal law, but certainly with DUI.
Find somebody who's trained to help you and take advantage of what their special gifts are, their unique talents are.
Yeah, no, you don't operate on yourself when you're sick. So,
well said. That's it for today's episode. Thank you so much, Ted, for joining me. I appreciate your insights as always. You have a way of walking us through these complicated procedures, and it's very helpful. Thank you.
Well, thank you, Lisa. Enjoyed being here.
That's it for today's episode of DUI Law Real Talk. If you or someone you know is preparing for a DUI court date in Georgia and has questions about what to expect, visit tedmorganlaw.com to schedule a consultation with Ted. And don't forget to like, subscribe to the show, and leave us a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.